Commercial Institute presenting shorthand dictation, legal and journal passages for upcoming SSC, PSC, Rail, High Court, District Courts exam at the rate of 80, 100, 120, 140, 160 and 200 words per minute. For acquiring 120 and 160 speed in a very short time, you should follow these guidelines. Practice this dictated passage 4 times at a stretch in a day. Practice each outline before taking dictation thoroughly, and transcribe and check your transcription from dictated passage which I dictated in this video.
Let's start. Code of Civil Procedure prior to its amendment by Code of Civil Procedure within the Amendment Act 1976 by sub rules within the 1 and 3 of Rule 72 Order 21 laid down that no holder of a degree in execution of which property is short shall without the express permission of the court be to for or purchase the property, and that where a degree holder purchased by himself or through another person without such permission, the court may, if it thinks fit, on the application of the judgment debtor or any other person whose interests are affected by the sale by order, set aside the sale in the state of Uttar Pradesh, the High Court of Allahabad, by an amendment made to the aforesaid rule deleted sub rules in bracket 1 and 3. The result was that in the case of a degree holder, the need of obtaining the express permission of the executing court before offering the bid for or purchasing the property put up for sale under sub rule 1 was not there, and the power of the court to set aside the sale under sub rule 3 of Rule 72 in the absence of such permission had also been taken away by the amending Act 1976. Several amendments were carried out to the code on the basis of the recommendations of the Indian Law Commission in its 54th report in 1973, since they were enforced in different parts of India. Several amendments to the code which had been effected by the state legislatures or by the High Courts of the Law Commission recommended that a new Rule 72A may be added, or Order 21 in which there was reference to sub Rule 2 and 3 of Rule 72-16 in sub Rule within the category of Rule 72A. Hence, even though Rule 72 was not amended by the amending Act, its retention in the form in which it was in the code had been recommended by the Law Commission. Section 97 with respect to 1 of the amending Act provides that any amendment made or any provision inserted in the principal Act by a state legislature or High Court before the commencement of its Act shall accept in so far as such amendment or provision is consistent with the provisions of the principal Act as amended by this Act, stand repealed. Respondent number 3 obtained a decree for recovery of money on July 29, 1977 against the appellant. In execution of the said decree, the immovable property belonging to the appellant was brought to sale by court on August 4, 1978, and that court shall respondent number 3 was declared as the successful bidder before the sale was confirmed. The appellant filed an application for setting aside the sale on the ground that the decree holder had not obtained prior permission of the executing court under Rule 72 within bracket 1 of Order 21 of the court. The executing court set aside the sale since admittedly no such permission had been obtained by the decree holder. The district judge affirmed the aforesaid order in a revision petition filed by respondent number 3 decree holder on the ground that on the commencement of the amending Act by virtue of Section 97 with bracket 1 thereof, the local amendment made to Rule 72 of Order 21 of the code prior to that date ceased to operate, and the code as amended by the amending Act applied to the case aggrieved by the decision of the district judge. Respondent number 3 filed a petition under Article 226 before the High Court of Allahabad. The High Court allowed the petition holding that since the amending Act had not made amendment of any kind in so far as Rule 72 of Order 21 was concerned. Stop. Thank you. Jai Hind, Jai Veera Bharat.